and was one of those who have been on the other side of the argument, the winning side of the argument on this constitutional amendment. Very nice.
Thank you, Charles. Good evening, our viewers, and happy Easter to you all.
Thank you. Gentlemen and lady, I want to start with a very, very broad question. And I'll start with you, Lord Mayor. You are on the losing side of this appeal to the Supreme Court. You and your team had lost in the Constitutional Court. And you, as a political actor, had lost in Parliament in 2017 when Parliament passed that amendment. Your impressions from the Supreme Court ruling?
Well, before I make my comment about that, I was intrigued by the observation you made about KK being one of the key people in the case on the government side. Personally, I didn't see him playing any active role in the case. Maybe you are rendering credence to the conspiracy theories that there are certain roles he plays behind the scenes.
No,
of these matters.
I can explain where I'm coming from. I know
well,
that
that was beside the point.
Just a moment. Just a moment.
Yes.
I can defend where I'm coming from. It's just the fact that I know from experience as a journalist that the teams that work on preparation of these cases are larger than the people you see arguing before the justices of the court.
But let's
I just didn't want to dwell so much on that.
But it is no secret that I actually hold the view that the age limit should be removed. So it's not a secret. Okay. I actually support that position.
You see, I just wanted to bring to the fore the conspiracy theories.
Proceed and make your argument, sir.
Doing rounds about KK and his team. Anyway, that aside, certainly this was a political judgment, a political decision, and it's very, very unfortunate. It's very absurd. It's both detrimental to the jurisprudence of this country as well as the political stability.
Why do you say so?
Why do I say so? First, on the jurisprudence of this country, it has set very, very bad precedents in our constitutional law. Very, very bad ones. Number one, they brought in two innovations within constitutional interpretations, novel principles of interpretation of the Constitution. One, the doctrine of substantiality, or the substantiality test, not the doctrine rather, to subject violations of the Constitution to that test which is applicable in election petitions. That, I think, was a misdirection on the part of the Supreme Court, the majority justices of the Supreme Court, because that test is not applicable in constitutional matters. So the question we always have to pose before the Constitutional Court, or even the Supreme Court acting in appellate capacity in that particular matter, is whether there was violation of the Constitution or not. If you answer the question in the affirmative, you are null. You don't go into those intricacies of saying how grave was the violation, how significant was it, how wide was it, what are the implications, and so on. You don't go into those intricacies. That test is only applicable in election petitions, where you are looking at the non-compliance with the electoral laws, and you say, oh, if there is substantial non-compliance, you are null. If it is minor and it doesn't go into the root, then you don't. So in this particular case, that novel principle which has been imported into constitutionalism is very dangerous. The second one, the misinterpretation of the doctrine of basic structure. I think it was a missed opportunity on our part to build our jurisprudence on that firm or rock foundation, where the Supreme Court would invoke its powers under the Constitution to call to order those who will be power to deal with our laws, to deal with the Constitution. That is the executive arm of government and the legislature, because they control the door. They constitute the bulwark against the violation of the Constitution. So in this particular case, they are shielded. There were innovations that were brought by so many other jurisdictions, democracies, specifically India, and quite a number of them in the Caribbean. You talk about Belize, there are others in Taiwan, Pakistan, South Africa, and even our neighbors here in Kenya. There is a case of Njoya versus the Attorney General, where they applied that doctrine of basic structure. And it is to the effect that there are certain pillars of the Constitution. Actually, it focuses on the spirit of the Constitution, on the philosophy of the Constitution. So they needed to focus on that. not necessarily to look at the letter of the Constitution per se. So now they restricted the applicability of the doctrinal basic structure to the entrenched provisions. And said the framers of the Constitution looked at particular provisions of the Constitution which are not
and chose to entrench them,
which are not so they said these ones are not flexible, this blah blah blah, and so on and so forth. I think that was superficial analysis. They should have gone much deeper, and that's why some of us applaud Justice Lillian Echiri Kubinza, because hers was thorough. I'll tell you, my colleagues here will agree with me. Charles, we have read decisions of the Supreme Courts elsewhere. This was below standard. If you look at those decisions made by the House of Lords, oh my God, you'd think I was amateurs, save for Justice Lillian and a few others. So in this particular case, they had that golden opportunity to help Uganda get back on the course of constitutionalism by adopting that radical or revolutionary doctrine of basic structure, which gives them wide latitude to deal with the political history of this country, which is born out of the preamble. The preamble is very, very clear, talking about political stability of this country, talking about the upheavals, the history of tyranny, and so on and so forth.
I have a copy of the Constitution here, and I intended to read through the preamble to the Constitution so that we can bring our viewers to speed with what has been at the center of this argument, because basic structure is primarily built in the preamble of the Constitution.
The preamble, exactly.
Constitution. Keke, please indulge me for a moment. Let me read this for our...
You see, for you to... Let's first get clear, Charles.
Yes.
For you to tell the viewers that the basic structure of the Constitution is built in the preamble is wrong. You see, that is wrong. The basic structure of the Constitution is not made in the preamble. Actually, preambles of any legal document do not form part of that document.
Oh my God.
Yes.
Oh my God.
When I'm reading the section of the law, I don't read the preamble. I read the section of the law. So what you want to be telling the viewers, that there are certain there were certain considerations that were taken into consideration when they were writing the provisions of the Constitution. The Constitutional Court deals with that. Okay. So let's first get that clear.
Just a moment.
Yeah.
That's why I asked you to indulge me. Let me read the preamble of the Constitution. And if you want, we can go into that deep analysis at a later stage. We, the people of Uganda, this is the Constitution of the Republic of Uganda. This is actually where it begins. Constitution of the Republic of Uganda, commencement 8th October 1995, the preamble. We, the people of Uganda, recalling our history, which has been characterized by political and constitutional instability, recognizing our struggles against the forces of tyranny, oppression, and exploitation, committed to building a better future by establishing a socio-economic and political order through a popular and durable national constitution based on the principles of unity, peace, equality, democracy, freedom, social justice, and progress. Exercising our sovereignty and inalienable right to determine the form of governance for our country, and having fully participated in the constitution-making process. Noting that a Constituent Assembly was established to represent us and to debate the draft constitution prepared by the Uganda Constitutional Commission and to adopt and enact a constitution for Uganda. Do hereby, in and through this Constituent Assembly, solemnly adopt, enact, and give to ourselves and to our posterity this Constitution of the Republic of Uganda this 22nd day of September in the year 1995 for God and my country. Sophie, I want to come to you. The Lord Mayor makes some arguments.
Can I conclude that point? Because I was interrupted by my brother Keke here. The issue here is not about the provisions which are entrenched and those which are not entrenched. It's about the philosophy behind the Constitution. And the philosophy, the principle underlying the doctrine of basic structure is that do not amend the Constitution to the extent that you destroy its original identity, its character. So in this particular case, you need to identify the character, the identity of this Constitution.
We'll come into that because I think that's at the center of the argument. And I didn't want us to get lost in, because you represent one side and beyond being a lawyer, you're a political actor.
Yes,
so there are certain views that you hold that might influence your interpretation of the law, same as Keke. That's why I introduced him the way I did. So if I want to come to you, what did you make? At least you're not a political actor like your colleagues. What did you make of the Supreme Court ruling? And I think it's important that we read the Supreme Court ruling as upholding a decision of the Constitutional Court in Mbale sometime back last year?
Well, thank you so much for that question. For me, I want to acknowledge a few things here. And to start with, I want to acknowledge that all the justices of the Supreme Court recognize that there were irregularities. And that recognition is very strong, because if all 7 are clear on it, it means that there's something that we need to work around and change in our processes and in our systems. And I think that's where the Lord Mayor comes from, to indicate that if there is an irregularity and you've recognized it, then go ahead and annul. But at least the most important thing is that they've recognized that. The other thing I want to bring on is that the Supreme Court decision also set a few precedents that we'll need to reevaluate ourselves as citizens around. In particular, it set a precedent on recognizing the role of the army in different situations, like in the actions of Parliament in particular, and the kind of violence they emitted, and the kind of role they played, which is in... you remember 2006, there was some bit of Black Mamba and a bit of not so sure if the army was actually involved, some saying it wasn't involved. This time round, it's on court record that they've recognized that the army had a role to play in this whole saga in Parliament, and it has recognized it. And that's a bad precedent for me. If going forward 2021, I think that's something that we need to work around. But also, the third thing, which is very, very important, is that out of 7, we have 3 judges and 4 judges. 3 are saying maybe there's something that we need to check. 4 are saying, I think the decision that Parliament made was okay. I think that, to me, is not too bad, because it would be worse if we had 1 judge against 6 of them, you know. But having 3 and 4, it means that there is some bit of review that we need to make, and some bit of evaluation on the different decisions that each of the different sides made that we need to make. Each of them brings something that is strong on our constitution that we need to recognize and then use it to be able to amend. Going back to the preamble, that preamble is the social contract that any governor of Uganda has to take at heart in governing Uganda using that constitution. So if it's the justices of the Supreme Court that are adjudicating on matters of constitution, that preamble is key to them, because it should be at the back of their minds when they are making any decision. If they are looking at a particular provision in the constitution, reading it alongside the preamble makes the provision of the constitution very strong and very valid. So you cannot disassociate the preamble from any other part of the constitution, because that's the social contract. The framers of that constitution, the Ugandan citizens, came together and agreed, recognizing the past where we are coming from. Because none of the framers, none of the Ugandans today want to go back to that past. So we want to always keep ourselves reminded of what that past was that we do not want. So the preamble is so important in this conversation, and that's why the base structure conversation is so key, is so paramount to this discussion, that if any changes or any amendments are to be made to the constitution, they should not be able to antagonize what we agreed on in the beginning, to make the constitution something, a different document. Today, not very many Ugandans can associate themselves with the Constitution and its provisions. Not very many Ugandans know even the provisions of the Constitution. The level of non-awareness of the constitutional provisions is so high that many Ugandans don't even know what kind of value they should accord to the Constitution, which is so much a problem for the Ugandans today, because this constitution is the determinant of so many other things that we need to be able to bring on board. So for me, that constitution is so key, that preamble is so key, that I think we should be able to uphold it.
Okay, now your time. Do you think the decision of the judges is good law?
Yes, first of all, I think the decision of the judges is good law, and we must also be clear that the decision of the court that I'm talking about is the 4. The other 3 are dissenting judgments, but the decision of the court is the 4.
Yes, the majority.
So, yes, the majority. But before we get into the detail of that, one, I want us to be very clear about certain things. Things that I do not agree with is this notion of name calling of judges because you don't agree with them. That has to stop. That is not the kind of thing we should be doing. These judges are entitled to their own opinion as much as I'm entitled to mine. So we cannot force upon them our own thinking. Otherwise, they cease to be the judges. That is why when we disagree, we go to them and we take the decision. That's what they've been given. So when we say it's a political judgment, it is below standard, that is not the kind of talk we should be having, especially in the company in which we do what we keep. So I want us to first start from there and first understand that this judge, when he sits there, he's entitled to his opinion. And especially when you're the losing party, it is natural to feel offended or to think that your argument was superior to the other one, but the judge didn't agree with you. So let's give them first of all that respect and call, and let's argue the decision of the court, and let's not name call. That's wrong and it's unacceptable. But the Constitution itself has that preamble that you have read. That is the history. The preamble summarizes the history of Uganda. And when that preamble was finished, then they wrote the provisions of the Constitution. Now, the people who wrote this Constitution were fully aware of the history of Uganda and then made the specific provision that are in the Constitution. So what do we do as lawyers? As lawyers, we go to the court to say that I am not happy or I do not agree with the way this provision is being interpreted or this provision is being violated. What is the court doing? The court is interpreting that provision, aware of the history, and it is whatever it is, using the evidence before them at the time. The Lord Mayor talks about substantial...
Just explain that one a little bit, because can you tear this Constitution apart and say from the preamble you can discard, have a different discussion? Are you talking about the same document at the end of the day?
Yes, and that is why
exactly.
That is why I'm saying that after they wrote the preamble, they went and wrote Article 259. Yeah, the framers of the Constitution were alive to that history, and then wrote Chapter 18 of the Constitution, and told the Ugandans who will come after them that whenever you want to amend this Constitution, you do it this way. You get what I mean? And they made 3 methods of constitutional amendment. They said certain provisions shall be amended by Parliament. Certain provisions shall be amended by district councils and Parliament. And the third category of provisions shall be amended by referendum and Parliament. You get what I mean? So the framers of the Constitution, alive to their history that you have just read, made those provisions. And the provisions that they put under the referendum, that is the people, and the Parliament, included, for example, Chapter 1 and included Chapter 4. Chapter 1 deals with the sovereignty of the people and the sovereignty of the Constitution. And Chapter 4 deals with the civil rights and liberties of people in this country. So they said, for these areas, if you want to amend anything around this, please bring it to me, the people of Uganda. Everything else, do it as the Constitution
guides you,
commands. So what the court is telling you is that the framers of the Constitution, in their wisdom, saw certain provisions as so sacrosanct that for you to touch them, you have to go back to the people. They didn't add 102. They did not add 102. Now,
and previously they had not added 105 2.
105.
102 B, yes.
It's not. It is not part of the framers of the Constitution and the people of Uganda, in the social contract they made, they said to this that say, you can do this. This you can do without even coming back to me. But when it comes to this, you must come back to me. And the court is telling you that in our understanding of this, all the 7 judges agree that Parliament had the power
to do the amendment,
to amend that provision. All the 7 agree. And all the 7 agree that that provision, I mean, all the 6, I think, agree that that provision 105 did not form part of the what? Of the basic structure. Now, I do not see how you can ask the court to tell the public that their Constitution allows the Parliament to amend this provision, but we, the courts, the 7 of us, have decided that that provision, despite the fact that the Constitution allows it to be done, it should not be done. That would be wrong.
So, okay, what's your understanding of basic structure? Could you help us understand what is basic structure for the Constitution?
First of all, basic structure of a constitution is not of any constitution. There is nothing in the world like a basic structure.
No, basic structure of a constitution.
Let me explain
the
this.
Ugandan.
Every country, every social setting has its own basic principles.
Sure.
In India, they have their basic principles. In Kenya, they have their basic principles. So I need the viewers to understand that there is nothing like a basic structure for all constitutions in the world. Now, in our case, my understanding of the basic structure are those things which the constitution does not allow you to touch on your own. And that's what the court said. I don't see how anyone can blame them.
Okay.
Now, when we come to the issue of substantial test, I don't even know whether we read from the same constitution or we read from different constitutions. And for someone to come and say that the court introduced a new provision, a new standard in the constitution, it just baffles me.
Called
Constitution, supremacy of the Constitution, Article 2 reads, Article 2.1, the Constitution is the supreme law and shall have the binding force of all authorities, on all authorities and persons throughout Uganda. We're all agreed on that. And 2, it says, if any other law or any custom is inconsistent with any provision of the Constitution, the Constitution shall prevail, and that other law or custom shall, to the extent of the inconsistency, be void.
So that's the substantiality
To
for you.
the extent of the inconsistency. This Article 2 places upon the Constitutional Court the duty to determine to what extent that law is inconsistent with the Constitution.
Okay. Thank you.
And when let me finish this. I need to finish this one. When the court was looking at this provision, it looked at the 6 provisions, and that is the original former Jersey provisions, and the 2 that were added, that is term limits and 5 to 7 years, and said, to the extent these 2 provisions are inconsistent, so that's what they removed. So the substantiality
is a creature of the Constitution.
Is a creature of the Constitution.
Okay. We'll go back into that. I want to hear from Councillor Elias Lukwago.
Something that Sophie said.
Just a minute. Yes.
I want to acknowledge something.
Just a minute. Just hold your guns for a moment. When we come back, you will react to that, and I will ask Councillor Elias Lukwago. I'm not qualified to call you Councillor. Your colleagues can call you Councillor. I'm told that
no,
that's a
you
peerage.
can call him Councillor. You just can't call him
for you.
friend.
Not a friend. Okay. Elias Lukwago and Sophie, to help us understand this whole question of the substantiality, I mean the basic structure question, your different interpretations, and then we'll go into the politics of this. And because I still think that the preamble to the Constitution is an integral part of this Constitution. And to read your chapter, the chapter 4, and which is the provision on rights, without the preamble, you're not reading the same document. My interpretation. We'll have a debate about that after a very short commercial break. So I'll come back to you on basic structure, your interpretation of basic structure, and then we can go into the arguments that the Supreme Court judges raised in their judgments, in their judgments read out on Thursday. We'll be right back. You're still watching the Fourth Estate, and we are discussing the ruling of the Supreme Court, or the judgment of the Supreme Court on Thursday, in that electoral petition over, that petition over the amendment of the Constitution in December 2017, which removed the upper age cap and lower age cap, allowing for anybody above 75 years to contest and run for the presidency. And I have with me in studio, I have Elias Lukwago, in his capacity as a lawyer, but he is also the Lord Mayor of Kampala. I have Sophie Chagulanyi, she's also a lawyer, working with Oxfam International, and Kiriowa Chiwanuka, who's also a lawyer. Lord Mayor, let me come to you. The argument that KK raises, someone says KK is being tricky. Someone sent me a message and said KK is being tricky. I don't know what that means. But he argues about basic structure. Says if you're interpreting this Constitution, yes, read the preamble to arm you to understand the history, where the country is coming from, where it is and where it wants to go. and then go into the actual articles of the Constitution and interpret them for what they are. You argued about the basic structure and said the judges failed the test, in your view, on basic structure of the Constitution.
I think Keke will do better by educating himself more about this doctrine, basic structure. It seems, with all due respect, he hasn't taken time off to understand the full import of that particular doctrine. That's why he's just restricting it to the limitations provided for within the framework of the text of the Constitution, and that is wrong. The doctrine of basic structure focuses on implied limitation on the amendment power of Parliament. For him, he's talking about the express limitations which are clearly spelled out within the Constitution. That if you want to amend particular provisions of the Constitution, this is the criteria you have to follow. Either you do it through Parliament exclusively, or Parliament with the local councils, or through referenda. That is a different aspect altogether. So the doctrine of basic structure goes beyond that. It looks at the implied limitation on the amendment power. And that is the philosophy. So it specifically, actually it is twofold. I'll look at it from that particular angle. One, don't amend the Constitution to destroy its character. So you look at the character of this Constitution. What is its identity? It's a Constitution which is intended to create political stability, to close that chapter of tyrannical rule in this country. It looks at that history. So it's a watershed constitution which looks at the history and focuses on the future. Now, if it's a watershed constitution, does it still hold that identity, character, after all these amendments, the removal of the term limits, the removal of the age limit? So it is now becoming a shell which has lost its identity. And that is a negation of the doctrine of basic structure. I'll not go beyond that. Secondly, there is the doctrine of purposive interpretation of the Constitution. Okay, it's not only amendment for the sake. Let's read the provisions of Article 79. Article 79 clearly states that Parliament has got power to amend the Constitution, or to alter any matter for there are two elements brought out.
You're reading the wrong provision.
Please,
let me read it for the viewers.
Please.
Let him read Article 79.
Can you be civilized enough to listen to me?
Let's read Article 79.
Can't he listen to me? There are four elements for peace, order, development, and good governance.
Can I read Article 79?
Let's not mislead
Article 79,
Article 79
yes.
of the Constitution, Clause 1, subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda. Clause 2. No. Except as provided in this Constitution.
That's not applicable.
Yes, this provision relates to laws, not amendment of Constitution.
Let us interpret Article 79.
Article 79 does not...
Can you listen?
Charles,
please.
why don't you listen?
KK, I am...
but if we mislead the viewers,
just a moment. I will read Article 79.
Read it for the viewers so we know, then we can continue.
If you speak the different article...
We can show him where the correct one is.
Let me read the other two clauses.
I'm talking about Article 79(1).
Yes, Article 79(1), subject to the provisions of this Constitution, Parliament shall have power to make laws on any matter for the peace, order, development, and good governance of Uganda.
Yes, this is what I wanted to interpret.
Sure, go ahead.
Number one, look at this emergency bill and the final product, the Impand Act, the Constitution Amendment Act. Was it meant to create peace, order, development, or good governance? And their lordships failed in that duty. Actually, I didn't hear any of them addressing their minds on that particular provision. And it featured prominently during the hearing of the matter. And that sets the standard, the test. For any legislation you have to make, it has to pass that test. So it's not open to Parliament that they have that unfettered power, the prerogative to amend the Constitution the way they wish, the way they deem proper, as long as they comply with the procedure. No, it's not all about the procedure, but even that test under Article 79. You can comply. You can say you have the powers to amend without going through the referendum. You have the powers to amend without going through the local councils. But have you passed the 79 test? The 79 test is very clear. Is it for peace, for order, development, or good governance? I must say it's none of those four. They never certified that test. And therefore it's bound to collapse on that basis.
Do you want me to read for you also, based on your argument, to read for you also clause 3?
Yes.
Parliament shall protect this constitution and promote the democratic governance of Uganda.
That is Parliament defending the constitution. So it's not about the power to make laws, to amend the constitution. In this particular case, they were making a law to amend the constitution. Is it for order, for peace, for development, or good governance? I leave it to the viewers to make their own judgment. I'll move on to another one.
Sure.
Article 126, the power of the judiciary. They are supposed to exercise, actually the Constitution, Article 126 is very clear, that the power of the judiciary is derived from the people and must be exercised in the name of the people. And it must be done, this is the most important thing, it must be exercised in conformity with the law, that is 1. 2, with the norms, values, and aspiration of Ugandans. So in this particular case, did they assess this particular Impande Act, the Constitutional Amendment Act, as against that test, whether it's in consonance with the values, with the norms and aspirations of Ugandans? I did not hear them saying so, because it does not stop at that. Lastly, on the question of the substantiality test, I think my brother was completely off on this particular issue when he cited Article 2.2. Article 2.2 brings in the doctrine of severance, not the substantiality test. Severance. That they can annul a particular legislation or a custom or anything that is done by Parliament or anything that is done by the executive or any act to the extent of the inconsistency. That is the doctrine of severance. And this way I also fault their law. It's not about the substantiality test. The substantiality test, the way they applied it in this judgment, is to say the violence that was meted out against members of the parliament, they all condemned it. The invasion of parliament by the SFC. To the extent that they even quoted the speaker's letter. The absence of the certificate of compliance, which the speaker, clearly, they all faulted it and said it was defective. They also talked about the lack of the involvement of the people, consultation, that it was inadequate. It was not there at all. So in that, and all other transgressions, like the speaker getting powers to adjust the order paper, bringing in this the emergency bill, smuggling it onto order, and so many other things, which I may not list here. But the point, in summing it up, they said, yes, with all these transgressions, with all these violations, did they vitiate the act? They were looking at the focus, and on the process. And here, this is where they went wrong. In applying the doctrine of severance, you sever, yes, it is applicable under Article 2.2. When you are dealing with a particular provision of the Constitution as against an act of Parliament or a particular provision of an act, of a particular enactment. So if you are assessing the validity, the constitutionality of a particular provision of an act of Parliament or an act with small a as against a particular provision. So if you are dealing with the particular provisions of the Constitution, of an enactment, you can say yes. Yes, there are these provisions. You can. Let me conclude the point so that the viewers get it clear. Sure. That this particular provision can be saved. These ones can be annulled. So you can sever off particular provisions. But when you are dealing with a process which is flawed, a process which is riddled with fraud, which is riddled with illegalities, with the transgressions, there's nothing to sever. You can't apply the doctrine of severance. And this is where they went wrong. Okay.
And in this case, you're referring to the 4 judges.
The 4 judges. Yes, of course, the rest didn't apply the doctrine of severance in this particular, because it dealt with the process as opposed to the express provisions. But in totality, The doctrine of basic structure focuses on the philosophy of the Constitution. And we are saying this, their judges lost it out on this. They betrayed the people. They betrayed the people when they decided to overlook that very important doctrine which saved India against catastrophes, which saved countries like Belize, Bangladesh, and others. So in this particular case, they were supposed to say, no, we are guarding the sanctity of the 1995 Constitution. It was meant to create political stability of this country. Now that you are removing all these safeguards, the safe nets, you are rendering it hollow, you are making it a paper tiger, and you are setting this country on a course to a violent change, which is very, very unfortunate.
Sophie, let me come to you on this. You're discussing the law, but you're also discussing the politics of it. This constitution, everybody has argued about the political context in which, one, the constitution was written, and two, the context in which it has been amended. And that's, I think, the basic, or the basis of this basic structure doctrine that Elias Lukwago and KK are arguing with different viewpoints. I want to hear from you the political context. Do you think, in your view, the Supreme Court judges and their colleagues, their lordships in the Constitutional Court, were alive to this? Because it's one thing to say one side of the political divide believed or interprets the law in this way, and the other side interprets it in a different way to suit their own context. You do not fall on either side of this argument. But if you place the politics of the country, because KK is arguing the process, and the judges agreed the process was okay. The Constitution allows that. Majority of them, the Constitution allows it to be amended the way it was amended. But if you're looking at the Constitution and you're looking at the history of this country, do you look at just the process? What else would they have looked out for?
Well, in my view, I think it should have gone beyond the process, because there's so much that defines the result that is not only the process. And I think that's where the political question comes in. And the political question doesn't only come today. I think Uganda, we still have a challenge as a country to go beyond the political. And the different arms of government have that big challenge as well. When you look at parliament, the way it deliberates its business, when you look at the judiciary, the way it deliberates its business, we have a challenge. This is not only for the current setup of the different arms of government. It goes back to the times of ex parte matev, for instance, where we have never moved. It's always the political that defines what kind of decision these two different arms of government will take, which is, I think, a very big challenge. So when I say they should have gone beyond the process, recognizing that there are certain irregularities or transgressions that are the cornerstones of this constitution, and they were missed in this particular situation, like, for instance, consultation with the people. This particular provision that was under amendment is a key provision that defines how people's choices are going to be defined in a particular set of elections. So by removing it, it is the second, it was one of the two safeguards we had in the Constitution. The first one was removed. Now this was the last one. Just removing it without consulting the people, I think, is a very, very grave issue that we need to consider, because the framework, the base structure, as they are talking about it, also recognize the role of the people either in the making, in the amendment of this constitution. So if consultation did not happen and the voice of the people is not on record, it creates a situation where it's going to be very normal for people's voices to miss out in particular in these scenarios, and to miss out in important decision making for this country, which I think is very grave, that we need to really be able to speak about and address, so that we prevent the issue, the challenges that may come out of that.
Okay.
Then
yes, go ahead. Go ahead.
I think the Supreme Court and maybe the judges in Bali need to rise above the political. Judicial activism calls upon judges to rise above the political, because they are a different arm of government. They are considered to be an independent arm of government. So rising above political would mean that they make the right judgment for Ugandans and Uganda. The right judgment for Ugandans and Uganda would mean that where it is 3 or 4, still there will be a feeling that, yes, this is the right judgment. But here we have 3 or 4, but still the feeling is that this is not the right judgment. So you see, that's what I'm talking about when I say the right judgment for Ugandans. Ugandans must be able to evaluate the decisions of the judges and be convinced that with the evidence they had on record, they were able to speak about the issues that concern them as Ugandans. When Lord Mayor brings out a few things that the judges were not able to speak to, and were not able to deliberate in their judgment, it means that there is a particular level of engagement that Ugandans expected the judges to have, and it did not happen. And that means that it will always be a gap in constitutionalism in this country. It is not helping us to move ahead, which creates a different situation, because 20 years after our constitution, 23, 24 years after our constitution, some of these things should not be a challenge to either the Ugandans or the Supreme Court judges themselves. So we should be able to rise above that.
I'll just take a couple of messages and then come to you, KK. One message is from Margaret Muhanga, who says, thank you, KK, for educating Arias Lukwago on the provisions of the law. It's absurd when they, opposition, win a court case, they applaud judges, and when they lose, they call them names. They think everyone should do things their way, or else they'll face a barrage of insults. Nteja Asimwe says, Lord Mayor, the irony about your profession is that it lacks uniformity. How can 4 judges say X is right and 3 judges say X is wrong on the same matter? Do you think this case was judged legally or it was fixed politically?
And in the lower court, it was 4-1.
May the best candidate win in 2021. Another viewer here says, unfortunately, NRM is legalistic but not wise, bearing in mind the foundation, methods, and procedures through which those laws were made. For instance, the law that allows anybody as young as 20 years to be a president of this country as long as he wins elections. KK, I want to come back to you. The major question that Ugandans will be asking is not that you insist that the processes were okay.
Yeah.
All bad laws in other countries, the processes and the laws were okay. In apartheid South Africa, the law was okay, legalistically speaking. In segregated United States, the law was okay as it was written. But you said at the beginning of the discussion that every country has its own basic structure.
Yes.
You said Kenya has its own basic structure, India has its own basic structure, the United Kingdom has its own basic structure, South Africa has its own basic structure. It is the need for these countries to move beyond. And people are looking at this constitution and saying, look, you've knocked at the corners of this constitution in the less than, since 1995 to now 2019.
24.
24 years of existence. You've been knocking at its corners, and someone looks at it and says, is this the document that Ugandans set out to do? The best question is, why did Ugandans set out to do this document?
Yeah.
What have you removed from it, and why have you removed in those 24 years to say it maintains its basic character, as the Lord Mayor is arguing?
You see, I'm going to try and make these, first of all, I'm going to try and keep my arguments legal, but also understanding my political view of things here. Basic structure, I want us to be very clear, is not a universal principle.
Agreed.
It is set in every circumstance. In our case, the framers of the Constitution determined for you what it was. If we think we have now gotten to a point where we need to change what our basic structure is to include the Uganda Law Commission, why isn't Uganda Land Commission a part of the basic structure? Why do you think that you must concentrate on a particular provision? Why do you think that a few speakers hold the view for the people of Uganda? Now, those are questions that anyone who feels that there is a basic structure that needs to be put in the Constitution which cannot be changed, even that is provided for in the law. If
no, I think the argument is a little different here.
No, the
argument is that you think, in your argument, that this country has so dramatically changed in the last 24 years that what guided the thinking of the makers, the framers of this constitution 25 years ago has shifted dramatically that you can pick and choose what you want in this constitution and what you don't want.
You see, now
and some people arguing that half a decade, that quarter a century is so short a time for you to be.
But you see, that is the problem that we are having here. What you think and what the other person thinks and what they believe must all be done within the context of the rules that govern all of us.
Agreed.
Now, if you feel that there are provisions that should not be touched, you go to the Constitution through the same processes of the Constitution and entrench them. Do you get what I'm saying? If you think the basic structure of the Constitution is being changed or it is changing and you think this is a safeguard, the safeguard in this Constitution is in Article 1, the power of the people. These people who are sent to Parliament do not walk there by mistake. They are voted there. So the political question you want the court to decide, it is wrong for someone to sit here and say that there must be a purpose. The court should go and look at the provision of the law and look at the value, the wishes of the people of Uganda. How is the court to measure that? The court measures that through evidence. The court measures the values of people through evidence. The justices of the Supreme Court cannot leave their courtroom, walk outside and go to City Square and call people and ask them for views. That's not what the court does. You go to court with evidence that the values of the people are these. What they have on evidence on the Constitutional Court, both in the lower court and the Supreme Court, is evidence of 230 members of Parliament who are saying we consulted and this is what we got.
But these same judges, just a moment. These same judges, 7-0, say part of that argument, fault part of that argument, because you had to send in the military. Or whatever. That the military, just a moment, that the military had to go into the chamber of Parliament as part of the process that makes these views of the Ugandans.
First of all,
that just a moment, that the consultation itself, was it adequate consultation or inadequate consultation to involve the people of Uganda, Article 1 that you're quoting here. That this is part of the broader argument that also these same judges of the Supreme Court and of the Constitutional Court are Ugandans who live in Uganda. Thank God all of them are elderly. They have been in this country and they have seen history. They are alive to the history of this country.
Charles,
yes,
please let us not blame the judges for our inadequacies. The judges, the fact that they live in this country and they have seen things out there does not give them the mandate to use that information. If the petitioners felt that that evidence was important for them, they should have brought it to the court. Now, let me finish.
Please allow him to finish.
Okay. The army was in Parliament. That is not disputed. The reason why the army was there was explained to the justices. They were called in to help. Even the justices say the members of Parliament brought it upon themselves. But anyway, the army has been in Parliament. It represents members of it has representatives in Parliament. So they participate in this process. The only difference is that this time they came in for security purposes. So, but let me finish my points, Charles, without first being, you can note the question so that I can. There are many things that were raised that I want to say. One, I've said basic structure is not a universally applicable principle. It is based on every circumstance of every country, and Uganda has set the standard for its basic structure. And the 6 justices actually agree on that. So we are here talking about it's not even 4-3. Constitutional interpretation. Constitutional interpretation, my learned friend is talking about purposive interpretation. First of all, before you go to purposive, you go to actual, the words in the Constitution. Now, the court cannot be required, colleagues.
And the history of the country.
And the history of the country, even it in their minds.
One of the principles.
Even that in their minds.
Yes.
My learned friend, you must bring the evidence before the court that the values are going to be taken away, that we shall have tyranny. Bring the evidence that we shall not have democracy. Bring the evidence. The court cannot say that, oh, now when you remove age limit, there will be no democracy, but there is an election under Article 1.
Can I respond to that?
No, I'm responding to you. Where the people dealt with this. Now, number 3, all the 7 justices agree that there is no implied power of amendment. It doesn't exist. That's not law. There is no implied power that the parliament can Parliament can amend, but the court can say there are some implied provisions which are behind these provisions, which you must consider. How do you consider them?
I thought that was the center of this argument.
That's what I'm saying, that you can't. That's what I'm telling you, that the court cannot read this constitution and go behind it and say, in fact, last night there was a theft or a burglary at my home,
so you think,
and therefore I must read this provision to mean that when the police is acting, it shall do this way, because no, that can't work. That is the job of the petitioners to bring the evidence. In as far as I'm concerned,
you think the three judges who interpreted it that way were wrong?
That's what I think.
Okay.
That's what
I need us to take a quick break. Our time is out. But let me take a message. Agaba Bills, I think, says this ruling is a continuation of Uganda's lack of a common vision upon which legislators make laws, judges serve justice, and politicians agree to disagree. That's his view. I take it's a fairly longer message from Ivan Okuda. I'll take it. I'll take bits of it when we come out of the break. Yeah? Yeah, we'll not have all the time to answer all the questions. I'm afraid. That one I plead guilty to. Someone says, let Kirioa Kiwanuka read that before making his arguments. I'll read through first and then tell you what he was writing, because I haven't opened it. Yes, he's reading it. The basic structure doctrine is an Indian judicial principle that the Constitution of India has certain basic features that cannot be altered or destroyed through amendments by the Parliament. Key among these basic features, as expounded by its most prominent proponent, Justice Hans Raj Khanna, are the fundamental rights granted to individuals by the Constitution. The doctrine thus forms the basis of a power of a Supreme Court to review and strike down constitutional amendments and acts enacted by the Parliament which conflict with or seek to alter this basic structure of the Constitution. It's a fairly longer one, but you can read it on your own later. Let's take a commercial break. When we come back, we'll pick this debate up. You're still watching The Fourth Estate, and this is the last segment featuring Arias Lukwago, the Lord Mayor of Kampala, and also a lawyer. Sophie Chagulani works with Oxfam, but she's a lawyer, and Kirioa Kiwanuka, also a lawyer. Gift of Nansana says, having seized power as the head of a rebel army in 1986, Museveni is not only one of Africa's longest-serving leaders, but he's also the only president most Ugandans have known in a country where the median age is less than 16. Having scrapped off the two-term presidential limit in 2005, which has allowed Mr. Museveni to keep running for office, the only hope for Ugandans to get rid of him was the presidential age limit of 75 years. And now that it's no more, Ugandans should just sit and watch the movie. Bwana Keke should be reminded that this law will remain largely inconsequential because it was passed against the wishes of majority of Ugandans. For that one, there is no question. What do you say to Gift? Gift has been recuperating in India, where he's been undergoing treatment. Okay. Let me ask. I think I missed my microphone, dropped off a bit at some stage. Let me read this message from Gift of Nansana. He says, having seized power as the head of a rebel army in 1986, Museveni is not only one of Africa's longest-serving leaders, but he is also the only president most Ugandans have known as a country where the median age is less than 16. Having scrapped off the two-term presidential limit in 2005, which has allowed Mr. Museveni to keep running for office, the only hope for Ugandans to get rid of him was the presidential age limit of 75. And now that it's no more, Ugandans should just sit and watch the movie. Bwana Keke should also be reminded that this law will remain largely inconsequential because it was passed against the wishes of majority of Ugandans. That one, there is no question. That's a message from Gift of Nansana. And Gift, we are hoping that you're recovering and progressing well with your treatment. The other message was from Muhimbo, the one who, Muhimbo Adiere, who was reminding you to read where the basic structure comes from, the Indian origins of the basic structure. Lord Mayor, you wanted to say, you wanted to respond to certain things before we took a break. But let's cut this for what it is. When this constitution was made in 1995, the major debate was how does a country, which I think at the time was about 24 years after independence or less, manage its transitions of power? Because at the time you had gone through coups and through wars to change power from one leader to the next. Some leaders stayed for as short as 68 days, others 3 months. There were others who stayed, the longest I think was 8 years. Idi Amin, Obote had been president and then overthrown and then came back. That was the context under which you're having a discussion. Today you're having this discussion when you have had consistent elections for the last for the last 20 years. You've been having consistent elections. President Museveni has run in all these elections and emerged winner. Are you just discussing the law? Are your arguments, yes, they might be legalistic on basic structure. Is that exactly what you're trying to deal with here?
Well, the central focus is on that exactly. That you see, the 1995 Constitution was intended to create a new political dispensation, a new order, a new constitutional order that would guarantee orderly succession to power. That would put, would close the old chapter of changing governments using the barrel of the gun. That was the primary purpose. And this, in taking a decision on this matter, their lordships, the justices of the Supreme Court, ought to have had that fact at the back of their mind. And that is the full import of the doctrine of basic structure. It is intended, listen, and I think after here, I'm sure you regret, after reading much about this document, after reflecting on it, you regret the statements you have made here. If you're honest, if you are true to yourself, if you are not disingenuous, let me tell you this. Because if you had read it, you would understand what it's all about.
I have read it and understood it.
Let me complete my argument.
Probably only better than you.
Let me complete my argument.
That's where the problem is.
Let me complete my argument. What it's all about is, please, don't tinker with the laws in such a manner that will distort, disfigure the text as it was originally envisioned by the people or the framers of that particular constitution. And that is the full import of that particular doctrine. So when he talks of the limitations enshrined in the constitution, that's a parochial, narrow perspective. In India,
KK argues that as a lawyer who actually was before the Supreme Court judges and before that before the Constitutional Court, you failed to make your case.
That's where I was heading.
Yes.
He talks about the purposive interpretation, that it had to be informed by evidence. If he cared enough to look at the record, he would see that we brought, actually there was nowhere we were faulted for having failed to adduce cogent evidence, adequate evidence. Nowhere in the judgments that on this matter you failed. On the purpose, listen, and I keenly listened to the judgments. None of them pronounced themselves on this, on the purpose of that legislation, because we brought evidence, cogent evidence, to prove that actually the sole beneficiary of this act was none other than Mr. Museveni. And the intention, the purpose of that legislation was essentially to make Museveni eligible for re-election indefinitely. And we demonstrated that, we brought evidence. None of the justices pronounced themselves on this. Listen, that negates the spirit of the 1995 Constitution. Indefinite eligibility of one person holding onto power, stifling competition within the country, and also creating a situation whereby, by the way, if you, this very Supreme Court, which initially had even issued a directive for electoral amendments, which have not been made, it is this Supreme Court, in all the decisions they have made in election petitions, the presidential election petitions, where they are all split along, the same lines, you do see their judgments have been consistent. Non-compliance with the law, not free and fair, but the violations or the breaches, the transgressions are not substantial enough to warrant nullification of the elections. That has been consistent. So, in essence, actually, they are aware, they are alive to the fact that in this country, elections have become illusory.
Okay.
They are aware of that fact.
And this
And
is
all
the
this-
person who
this-
is sitting as mayor of Kampala through an election. That's such a double standard.
Let me make this, and it's very, very interesting, Charles. Last year, around September, the judiciary inaugurated the Ben Kiwanuka Memorial Lecture. I attended there. And the key speaker was the Chief Justice Emeritus, Justice Wambus. And he made a very powerful speech. He delivered a moving speech. In the statements made by the sitting Chief Justice right now, listen to this is what he said. After listening to that beautiful message that was given by the former Chief Justice, he said, "Ladies and gentlemen, kindly sympathize with me. I'm sitting in a chair, the very chair where the former Chief Justice, Ben Kiwanuka, was grabbed from in broad daylight. And up to now, we are yet to trace his grave."
What does that have to do with the constitutional amendment?
Listen.
See, let him make his point. Go ahead.
I'm making my point here.
That's why the case is fair.
You see, this is what you call name calling. When I saw the Chief Justice failing even to read his own judgment, failing, literally, failing to read his own judgment.
You see,
This is not name calling. We are talking about independence of the judiciary. We are talking about a judiciary which is assertive. Sophie here talked about judicial activism. The situation we have right now
when you
calls
lose a
for
case,
an assertive
when you lose a
judiciary.
case and you start blaming the person for the job you failed to do, it's wrong.
Do you know the contents of
the
his
Chief
judgment?
Justice explained to you what the issue was. Let's have some respect.
I
Let's
hold
not
him in a high regard. I respect him
and
so
behave
much.
as such.
I
behave
hold him
as
in a
such.
high regard.
Conduct.
But
No,
I'm
no,
pointing
no,
out the
no,
fact that he did not read his judgment. That's a fact.
Don't
Did he
issue
read it?
innuendos.
Did he read the judgment?
Hold a
No.
moment. Honorable Elias Lukwago, the Chief Justice gave reasons why he wouldn't read his own judgment. And I think the reasons he gave are natural reasons.
Yeah.
He wasn't well. Would you fault him for that?
No.
Wouldn't anyone else read it for him?
But he was present.
Wouldn't anyone?
No, he could read it later. Why would that be
Charles,
important?
we are not
What
here
is
to
important
discuss
is that he
personalities.
was
You
not
discuss
well.
the issues.
Yes.
And
What
he
is
didn't-
important
and
is
very
that he was
clear.
not well and
Record.
he sat through.
And this,
Yes.
that is the kind of thing that we get off the point and start going to. We are discussing
KK.
serious issues
KK.
and you're now name calling. Stop that.
KK, can I moderate this discussion? Let me come back to you. You make the argument that the process is right. Granted. Elias Lukwago is raising the issues of where the country is coming from and where we are.
Yeah.
On what basis? Some people have argued this was a political judgment,
Yes.
not a legal
And
judgment
let me
per
answer.
se. They're saying you needed to go beyond that and say, look, the ultimate beneficiary of this amendment, and the amendment before it, is one individual called President Museveni. That the Constitution was made, and its preamble, and in the context that it needed to change a chapter in this country on how power transitions. That becomes complicated with these amendments of the Constitution. How do you respond to that?
Charles.
Yes.
When my learned friend sits here and speaks, he assumes that he speaks for everyone. He doesn't hold my view, and I'm sitting here.
Granted.
No, listen. So, I do not feel aggrieved because I have a right under Article 1 to go back and cast my ballot. I have the right. I don't feel aggrieved. So why is it that you will sit here and say the purpose for which the Constitution was made has been lost? I'm not aggrieved. I may hold the view of many others out there. I may hold my own view. Same thing. The Lord Mayor here may hold a view which he speaks of so animatedly, but it may be his own view. Now, as long as you do not provide the judges with empirical evidence of how you arrive at this conclusion that the people of Uganda, now there is no choice, we are finished, you can't help yourself. Now, the law as it is, as was originally envisioned by the constitution makers and this basic structure that we keep talking about, also made provisions for amendment.
Granted.
Now listen.
Yes.
What do we do with those? Do we say that now
They're about to imply
no,
delimitation.
there is nothing. I will challenge my learned friend Lukwago here to publish in the papers this implied power to amend the constitution. It does not exist.
A different argument will be made. A different argument will be made.
It doesn't exist. Implied authority.
Hold a moment. A different argument will be made. That the power holders of 1995 felt those provisions as they were then suited their purposes.
Yeah.
Whether this was representative of the views of a majority of Ugandans or not is out there for debate.
Exactly.
And the views,
Number two,
and those are
the views.
Just a moment. That the same power holders today, the political argument out there, beyond the law, is that those same power holders today have a majority in parliament.
Yes.
However, that majority is arrived at is a matter for a different debate.
Yes.
That those same power holders hold sway over the judicial processes.
No.
That the context in which these arguments are being held is not the context that you'd say the spirit and letter of the Constitution says this, the environment is this, and therefore whatever decision is made is guided by exactly that.
The people who existed in 1995 held the view that this constitution should be as follows. 24 years later, another group of Ugandans with as much rights as the one who existed in 1995 hold a different view. Now, why the framers of the constitution in 1995 put these provisions in? They said, in case the people who come after us change their views on some of these provisions, this is how they should go about them. But also,
you could take it back a little.
Also, they put a fundamental provision in here and said, but we shall retain one fundamental right for every citizen of Uganda to go and carry a question for the referendum.
Thank you.
Now, if a member feels that there is a provision in here,
can we give a little bit more context? Hold it a moment. Can we give this? Can we give this a little bit more context?
If you have so many people behind you, bring a referendum.
Element of posterity for you are talking about.
If you have the numbers behind, if you claim you have the numbers behind
but
you,
even the posterity,
if you think you have the numbers behind you, you have every right under the Constitution to move a referendum to remove that provision. Why aren't you doing it?
So
you have the numbers which you can't use.
Reducing the Constitution to an ordinary act of Parliament.
The Constitution is my social contract.
Gentlemen, hold it a moment. The same Ugandans who existed in 1962 at the time of independence held certain views about how the country should be governed. By 1962, a group of Ugandans who believed represented a majority of Ugandans or the views of Ugandans had views. In 1972,
1966,
1966, yes, I'm talking
4 years
about
after,
things
became different.
Yes, things became different.
Yes.
1972,
Yes.
there was a different
Yes.
arrangement at that time.
Yes.
And this was all Ugandans, by the way.
Yes.
Yes.
1979,
Yes.
there was a different arrangement.
Yes.
1980, a different arrangement. 1981, a different arrangement.
Yes.
1986, a different arrangement.
1995,
a different arrangement.
2005,
2001,
a different arrangement.
Yes. 2005,
No,
a
before
different
you go to
arrangement.
2005,
1995,
1995, they sealed in a constitution
A different arrangement.
saying that all these arrangements from 1966 up to today, I think we need to bear in mind that we need to transition as a country, transition to a peaceful society.
Sophie.
Yes.
And how do we drive that peaceful society? The constitution should guide us.
And
They put the buffers of
Okay.
those two age limits.
If that is the history we've been having, we haven't imported any other people. We've been dealing with Ugandans.
Yes.
What did this constitution seek to heal?
And
how do these changes of today talk about that question called posterity that the preamble talks about? And Sarah Birete here was sending a message. I'll pick it up. I think my phone is dying.
how many? What do you think, in your view, is the country with the best democracy? Which country do you think has the best constitution?
That's relative.
It's relative.
Yes.
Do you know any country which has had a constitution which has been stagnant for a while? I don't know it. You can.
I also don't know,
one.
but
I know that at every time things are changing.
changes.
You get what I mean? At every stage things are changing. And when things change, we must consider why they are changing.
Okay, let me ask.
The circumstances
This
obtained at the time.
constitution this constitution is 24
where a
years old.
constitution is tailor-made to suit the interests
interest
of one person,
No, I don't
like
know.
ours here.
You see, the problem is that
Like ours here.
it is suited to, you see, when
Okay.
It's to suit one's interest.
I told someone
you're
something
the lawyer.
interesting.
You're the
I
lawyer.
told someone
You guys are the
interesting
lawyers here.
that I'm going to try but today I'm going to try and keep to the law. But my learned friend here talks about it suits one person, and they have very many people who support them. But every time they go to the ballot, they lose.
Okay.
Okay.
Let me put the question. Yes, you're saying a constitution that
No,
how many constitutions have been amended as many times as the Uganda constitution, and they remain constitutions of their countries?
America has 48 amendments
48 amendments in how many years?
over a period of 200 years.
Yes, and Uganda has how many amendments?
8
amendments.
over 33 years.
No,
Eight times.
Even after 95, you can look at the 1999, an amendment. There were actually 2 amendments, 2005
Yes.
and 2011.
Look,
Then,
wow.
then the most recent one,
You see,
and you are lining up more.
You know what?
So
I'm
is that
answering
a
your
constitution which you are saying is
question.
durable?
You see, the constitution is durable not because of the number of times you amend it. It's durable. A constitution, by the way, is a culture. Mr. Lukwago
No, that's not true.
It is looking at it at this.
It is a constitutionalism which is a culture. The constitution is a document.
That guides the
There are some
culture.
unwritten constitutions, by the way. Are you aware of that? He doesn't know. But I will school you on that another time.
Okay.
What I'm saying is that
let me ask. In those 6 amendments, how many articles of the Constitution are affected? There might be 6 amendments, but always they are consolidated. They affect many clauses within the same Constitution. How many clauses?
I think about 46 clauses.
46 clauses.
Yeah.
And the American Constitution, how many?
It has 48 amendments.
48 amendments.
Yeah.
Affecting how many clauses?
There are 48 amendments because every amendment deals with a particular issue that they need to deal with at the time.
Let's put those amendments into context.
No, you see what
they are meant to enhance
The
fundamental rights, the
strengthen.
Bill of Rights. Those amendments made by America,
Yes.
they are meant to enhance,
Not to take away.
not to take away the rights.
What
But
rights has
here
been
you are,
taken away?
You are washing away the gains we have registered
What gains have you
through
registered?
thick and thin.
What
I
gains?
think-
Through our-
no,
our own
Mr.
blood.
Lukwago, you haven't.
I think
you
the
haven't
men,
done
on
it.
this panel are not allowing the voice of the lady to come out, so I'm going to give her the
I wanted to
opportunity.
speak about the domineering majority.
Sure.
And when the majority domineers and becomes the rule and becomes the decision of everyone, it's a big concern to Chapter 4.
How can we
because
deal with
chapter
that?
Exactly, that's what I'm
How
saying.
would you deal with it?
Chapter 4, as you said, is one of those that has been sealed in.
Yes.
That if you to amend, you go back to the people.
Yes.
So if you find that there's a provision inside there that would affect the equal rights that Chapter 4 provides, then you have to go to the people.
So what I'm asking is that,
Referendum.
so, and I'm telling you, I have told my learned friend here that the provisions of the Constitution, Article 255 gives him the right. The only difference with that Article 255 is he must have the numbers. He must get the numbers.
What are the
And what
things-
I'm telling you, beyond the Article 255, they are implied limitations.
no,
This
no.
is the point I
No.
was stressing, and I will keep on
Charles,
stressing.
You see,
Well,
and you
well,
see, and you see the problem
as Kenya would say, you make the
you have
argument and
stressed
the-
it.
the
You have
judges
stressed it
didn't
in
buy
the
it.
Court of Appeal. You lost
They
it.
bought it. By the way, they
Listen,
no,
you
no,
lost
no.
it in the Court of
Across
Appeal.
board,
You lost
across
it in the
board.
Supreme Court.
No,
Yeah.
don't misread.
So-
No.
How is it done
Let me
here?
correct the record here. They all agreed that the doctrine is applicable.
Yes.
But theirs, actually, it was the misinterpretation and misapplication of the same. To restrict it to particular provisions, particularly those which are entrenched.
Okay.
The question
Gentlemen and
for
lady-
interpretation
gentlemen
was
and
whether
lady.
102 was part of the basic structure. The justices of the lower court all agreed it was not part of the basic structure. The justices of the Supreme Court all agreed. I
But-
don't
but
think
they
you have
agreed
any
there is a
other
basic
place to
structure.
place that
Gentlemen
point.
and
You've
lady.
lost that
But the,
on that
but
question.
the
Gentlemen
point
and lady-
is, we
gentlemen
have a
and lady.
basic structure.
Gentlemen and lady, I want you to tailor your arguments as closing arguments because our time is pretty out.
Yeah.
It's almost coming to 11:30, and we need to get out of here. So, let me start with Sophie. Where do we go from here next?
Two things. There are precedents that have been set by this judgment. The politicians are ready to go to challenge. There's another court beyond Uganda,
Yes.
East Africa. That's okay. But I think for Uganda, we need to be able to take the good in this judgment and try to replicate it in our values, the value system that the Lord Mayor talked about. But also be able to guard against those particular actions, decisions that are going to challenge the power and the spirit and the position and the voice of the people. Because the power, the spirit, and the action and the voice of the people must be present in whatever decision, whether it is taken at the Supreme Court, whether it is taken by any court in this country. It should be speaking the voice of the people. Whether it is Parliament, it should be speaking the voice of the people. That should not be forgotten. And that's where that Constitution is the preamble of the Constitution is tailored from that. So going ahead with this, let's be able to pick on those that uphold that power, voice, and
maybe someone will ask, who are the people? How do you arrive at that voice?
The people are not me, are not my land friend KK, are not the Lord Mayor. The people are the ordinary Ugandans, are not the judges
does their
of the
voice
Supreme Court.
Get represented?
Exactly, and for me that is where I've been coming from. Judicial activism is one of the principles that requires the judges of any court to recognize that voice of the people.
KK
The
has been
evidence on
arguing-
record might not have brought out that evidence or that voice of the people, but the judges have a responsibility and a role to be able to listen to what is happening in the backyard, because it's one
KK
thing
and
coming
his
up with a
KK and his
judgment
friends
and it is
say-
disconnected.
Yes, KK and his friends say they have the people behind them.
And
that's
I
why they
agree,
go to-
and I agree. But he kept bringing about the ballot as one of the things that gives us another power to make any changes we want. The people of Uganda today do not believe in that ballot anymore. Why? As the majority, as the domineering voice with the numbers, they need to be able to question why are people no longer interested in going to the ballot. You see, the answer you will give me is that
but
who gives them the percentage?
Yes.
You know, because at the end of the day,
But
75%, who
if
is
you
in the
look on the other
75%?
side, those same people put people like Arias Lukwago into the mayor's
Parla.
parlor.
I agree, but
Yes.
but the same people, in different situations, they are not ready to act because they know that there will going to be a differentiation
Okay,
of
thank
their
you.
power.
Honorable Arias Lukwago, let me come to you. As we close this argument, where do we go next?
For me, my main concern is about the attitude of the people towards all these abuses. You see, I think Ugandans have given too much latitude to the people who hold sway,
Yes.
people who hold institutions in their name to do whatever they want, including even usurping their powers and sovereignty. I would tell you this: the executive arm of government is in cahoot now with the legislature to keep one man in power. Now, the judiciary, which under Article 126 is supposed to exercise power in the name of the people and in conformity with the norms and values and aspiration of the people, has also played the ball. And the Ugandans don't find fault with that. Majority, I'm not saying all of you, but Ugandans are quiet. On that fateful day on Thursday, I was shocked. You know, people not giving a damn to what was going on. Yes, they would comment in social media here and there, but Ugandans, without rule of land constitutionalism, without a political dispensation that guarantees orderly succession to power, you are going to see catastrophe in this country.
Wearing your other hat as a political actor, it means you have failed to effectively mobilize
No, it's not all about
the reasonable numbers of
you see,
Ugandans who would feel with you.
You see, this is a clarion call. It's not me to mobilize the people. Look at the provisions of Article 3 of the Constitution. It's a command. Ugandans must rise to the occasion. They must respond to that call, the constitutional command, that please, where you witness unconstitutional tendencies, please rise to the occasion. Come up, defend the Constitution. It's not a duty. And you find sometimes they castigate some of us who have, at least within our limited capacities, have decided to do two little things to ensure that actually we call these people to order.
Okay.
So in this particular case, my call to Ugandans, please, this country does not belong to the Lukwago's, does not belong to the individuals who are pursuing this cause, and don't leave it in the hands of these KKs to go into these illegal gymnastics, to carry out these distortions, to bastardize this country. Please, you have the powers to call the KKs to order.
Yeah, you're making a political argument,
still
not a legal one.
struggling
It's
with
a legal one.
putting
It's,
food on
it's
their
grounded
tables.
in Article 3 of the Constitution.
You see,
KK.
for me, the
yes.
KKs that they're talking about are here arguing, and the voters go and vote for them, who have failed you many times. Maybe next time I should turn against you and we consider this, because I have not come out into the political arena.
But when I come.
But when I come,
You are welcome.
yes. For now,
But
what I
still-
will stick to the law. All the 7 judges agree that the Majizi bill was good. All the 7 judges agree that the parliament had the power to amend the constitution. 4 out of the 7 judges say the constitution should remain amended. What I'm calling upon Ugandans is to really read your constitution. Read your constitution and understand what it is that you can do for your country, what it is that you can do to get our country out of whatever
Anarchy.
situation you may think it is. We have a fundamental duty under Article 1 to vote and to choose the leaders that we want to be chosen. I will only call upon you to think about these leaders as you choose them.
Okay, KK, just one question as we get out of here. Do you think that there is a possibility that a new political arrangement will find this constitution and say, well, we can save chapter 4 because it's a good chapter. We can save maybe aspects of chapter 1 and we can save we can save just a few pieces but discard the rest of the document. Is that
Every
possible?
provision in this constitution, old, amended, deleted, and existing, can be replaced into this constitution by the power of the people of Uganda. If the people of Uganda tomorrow feel
To the
that
extent that it retains its original identity and
Identity and
character.
no,
character.
that one, you see, for me, the original
It's
character,
qualified.
the originally envisioned character of 1995. In 1995, I was a law school student. Yeah, what did I know about
If they
life?
want to replace it, they can write a new one.
They can write a new one.
Yes,
the people of
but-
Uganda
but
can
you think that's okay?
No, the people of
Not
Uganda,
manipulating.
the people of Uganda can change this constitution in whatever form and say whatever they want. They can even say that they don't need a Lord Mayor.
Thank you. Our time
Thank
is
you
out. We
very
need to
much.
get out of here. We'll continue debating the question of posterity and what the thinking was then, what our thinking is on the panel here about posterity. Because if you say they can, those who come after us can take care of themselves.
Then
The best way they think they can.
That is
And those who came
selfishness.
before us. I think that's the argument you're making.
Everyone-
Selfishness.
I think that's the best argument you're making. That those who come after us can take care of themselves
No,
the
that's
best
not
way
what
they
I'm
think they
saying.
can.
The people of Uganda who are there today, if the provisions of the constitution exist, if they feel aggrieved,
They're not
they can still
necessary.
use them.
And you don't
But if
care
they
about
don't
the
feel
kind,
necessary,
What
the
about
type
the
of
people of
country
Uganda
we
who
shall
come?
bequeath
Them.
to our
Our time is
to our-
out. Our
to our
time is out.
children
Thank you
and
very much.
grandchildren.
Thank you
You're
very
the
much.
ones who don't care about it.
Thank you very
When
much.
you do a bad job, you get an opportunity before the Supreme Court and do a bad job. That's what we get.
Thank you very much, Kiriowa Chiwanuka.
One day
Thank
we
you
shall
very
tame
much.
that arrogance.
Thank you very much, Sophie Chagulanyi. Thank you very much, Arias Lukwago. Thank you very much to you, all our viewers, for joining us tonight and always. And of course, the production crew that's there played to deliver the show to you. From me, it's a good night.